Defensive mark. How does it differ from regular trademark? Let's take a look at trademark. So what is a trademark? A trademark is a way of identifying a unique product or service, sometimes referred to as a brand. It can help customers distinguish the quality of a product or service over another competitor. A trademark is not just a logo. In Section 17 of the Trademark Act 1995, it broadly outlines the definition of trademark, where it allows the registration of a sign used. A sign includes a letter, number, word, phrase, sound, smell, shape, logo, picture, movement, aspect of a packaging, or a combination of these, to distinguish goods or services dealt with or provided in the course of a trade by a person, from goods or services to dealt with or provided by another person. Trademarks are issued to give the owner the exclusive right to that mark, which allows them to take legal action to prevent others from using it. A trademark must be actively used in the course of trade. If not, it can be removed on the grounds of non-use. This is to discourage traders from registering multiple trademarks, simply to stop others from using them. And anyone can apply for removal of a trademark due to its non-use. The TM symbol stands for an unregistered trademark, and the R symbol in a circle stands for a registered trademark. A trademark registration lasts for 10 years from its filing date. Some examples of Australia's favourite trademarks include Arnott's, David Jones, Vegemite, Weet-Bix, and Qantas. As you can see, trademarks are everywhere and you probably don't notice it, but we encounter them every single day. Now let's move on to defensive mark. So what is a defensive mark? A defensive mark is a form of trademark that prevents infringement. In general terms, a trademark that is extensively used in Australia can be considered to be a well-known trademark, where it has gained recognition and reputation in the market, usually due to the high quality of goods or services. As a consequence, the well-known trademarks become known by competition, thus increasing the risk of misuse by third parties seeking to take advantage of the reputation. The purpose of a defensive mark is to provide the owners of trademarks which have been extensively used in Australia to have protection against the misuse of the trademark, in a manner which might diminish the value or reputation of the trademark. Additionally, it protects consumers from confusion and deception, which might result from a third party adopting a trademark which has been used extensively in Australia. Part 17 of the Trademark Act outlines the defensive trademark, and Section 185 is an important part that provides the circumstances under which an application for registration of a defensive mark may be made. The requirements include: the applicant must have a registered trademark. That trademark has an extensive reputation. The use of that trademark by another is likely to mislead consumers to think it has a connection to the original trademark, and proof of extensive evidence that a defensive trademark is applicable. Now let's consider an example: the trademark range, which is well known for wine and is registered for those goods. The trademark owner does not need the intention to use its mark for beers and non-alcoholic drinks, but is concerned that if any other party were to use Grange for those goods, the public is likely to be misled by assuming a connection or rights in Grange could be diluted. A defense registration covering beers and non-alcoholic drinks prevents a third party from registering a mark for those goods and provides the trademark owner with a statutory infringement action against unauthorized use of its mark for those goods. Thank you for listening. Hope you learned something about defensive mark today.